One of my goals is at our university to increase the academic and intellectual climate for both students and faculty by having more symposia and talks, and where, this is the key, or as Bill Clinton would say, listen, this is important, where you would show up not because you were required to, but because you are actually interested in getting the most out of your undergraduate experience. And I know that's asking a lot because I know it's a beautiful day outside, but I do think, whether you're required to be here or not, thank you very much for attending. I have the distinct pleasure of introducing our speaker. And it's not every day that you get to introduce someone who is a distinguished scholar, a great teacher, a colleague and a friend, who you also hired, because I hired her to the law school 10 years ago, she reminds me, which doesn't seem that long. But Alexandra, she goes by Sasha Natapoff, has an undergraduate degree from Yale in philosophy, and her law degree, or JD, from Stanford. Not a bad pedigree. She's a nationally known scholar and expert in the area of snitching, in terms of, and she'll explain it more, but in terms of the way that through subterfuge or gimmickry or planted informants that information is gathered that's used or tried to be used to convict the accused. And so she's, with her expertise, she's been featured on radio shows and NPR and TV and has lectured around the country. She has a whole bunch of awards, and I'm just to make sure that I don't sell her short, I'm going to mention a few of them. She has the ABA Silver Gavel Award, the 2007 Outstanding Scholarship Award from the AALS Criminal Justice Section. She's won the Stephen M. Block Civil Liberties Award for distinguished work relating to personal freedom, and she clerked prior to joining our faculty at both the Court of Appeals level and the District Court level. She currently chairs our Lateral Appointments Committee at the law school, which is the committee that hires already tenured professors to come in as senior faculty appointments, and she's a Theodore A. Brunsma Fellow. So as you can tell, she is quite a scholar, a terrific teacher, widely published, and I'm sure you will enjoy her talk on the right to counsel. Dr. Sasha, Professor Martin.
Happy Constitution. I'd like to thank President Burcham for having me today, Professor Gersman for inviting me. In particular, I'd like to thank President Burcham for the job, which I'm really enjoying. But more importantly, for the honor of getting to be with you today on Constitution Day, a day that we dedicate to understanding and remembering this crucial founding document of our democracy. So you all know the Constitution, right? Right. Okay, so you at least know the preamble. Okay, so you at least know the first 11 words of the preamble. Everybody knows the first 11 words of the preamble, right? Let's do this together. We the people, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, I lost most of you there, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. So we Americans, we are so spoiled, right? We're just used to having a constitution. We just take it for granted. In its day, at the time, this was a revolutionary document. Right? This, in effect, it was our Arab Spring. People died so this bit of paper could get written. And today we're like, yeah, there's an app for that. There actually is an app for that. My son showed me on my phone. Look, Mom, it's the Constitution. So as I reread the preamble, which most of you know some of for today, I was struck by the fact that the very first term in this recipe that the preamble gives us for a more perfect union, the first recipe is establishing justice. Apparently, the founders thought that before all else, before domestic tranquility, before the common defense, in order to have a more perfect union, we need to establish justice. Now, this is an important constitutional year. It's an election year, of course. And so we're going to hear a lot about the Constitution. We're going to hear about Article 2, which is the provision in the Constitution that governs the actual process by which we select our president. We're hearing a lot in the news right now about the common defense as the Middle East erupts in protest. And the candidates will continue to fight over the economy, healthcare, taxes, jobs. In other words, they're competing visions of how to promote the general welfare. But we are not hearing that much about how to establish justice. We are not hearing much about what it takes to make a just society or to have a fair legal system within that society. And so today, I'm going to talk about something that the people who wrote the Constitution thought was crucial to establish justice, and that is the right to counsel. So the right to counsel is in the 6th Amendment of the Bill of Rights, and it says, in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. Now, you might wonder, what do criminal prosecutions have to do with forming a more perfect union? But although we don't always think about it this way, and political candidates certainly don't talk about it this way, the criminal justice system itself is an immense and influential part of our democracy. First, it's huge, right? It's the biggest on the planet. The United States locks up more of its citizens than any other country, both as a raw number and also as a percentage of the population. Right now, there are over 7 million people actually under supervision by the criminal justice system at any given time. Over 2 million who are actually incarcerated in prison or jail, about another 3 million on probation, another 2 on parole. The criminal system employs hundreds of thousands of people. It spends billions of dollars, and it affects the daily lives of every single person in this country. In other words, it's a central part of the way we have chosen to govern ourselves. So I'm going to guess that many of the people in this room are not yet 23. So I want you to just count the number of years you have left until you turn 23. So if you're 19, you have 20, 21, 22, 23. So hold them up. If you're old like me, you go like this. So in this country, over 30% of all Americans are arrested at least once before they reach the age of 23. And that's how you know how pervasive and important our criminal justice system is, how easily it can touch our daily lives and the lives of people we know. We rely on the criminal justice system to do all kinds of work, right? To educate, to control people's behavior, as well as, of course, to punish people. And by the way, just because it's an election year, I have to say this out loud, that 30% number is larger. It is a greater number than the percentage of young people who voted in the last midterm election. Just saying. So the founding fathers thought that a just criminal system was so important to a perfect union that they laid down some very specific rules. And the most important of those rules is the right to counsel itself. That is, the right to have a lawyer who understands the rules of the system and can deploy them on your behalf. Sometimes we say something like, the right to counsel is the right that enables all the other rights. Because without a lawyer, it's unlikely that we will benefit from all the other rights that the Constitution confers on us. It was not always clear, as a historical matter, exactly what the Sixth Amendment meant in practice. But 50 years ago, in 1963, the Supreme Court decided one of the most important cases in determining how our criminal system would actually work. In that case, you probably heard of it, is Gideon versus Wainwright. And it was in that case that the Supreme Court had to decide whether people accused of crimes by the government would have a lawyer, or whether they would have to face the government all on their own if they could not afford to hire a lawyer for themselves. And so here's what the Supreme Court said. It said, the assistance of counsel is one of the safeguards of the Sixth Amendment deemed necessary to ensure fundamental human rights of life and liberty. The Sixth Amendment stands as a constant admonition that if the constitutional safeguards it provides be lost, justice will still not be done. In our adversary's system of criminal justice, any person haled into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided to them. And so it was with that the Supreme Court created the constitutional right to counsel as we know it today. Well, 50 years later, our criminal system is vastly larger and more influential than it was in 1963. It affects more people, more families, more communities, more 23-year-olds than it ever did before. What happened to Gideon's right to counsel? Well, as with so many of the other grand ideas in the Constitution, it has not fared that well. Of all the people who are brought in to the criminal justice system, 80% of them cannot afford a lawyer. And so the government has to provide one, has to appoint counsel for them. And these lawyers, public defenders, are famously overworked. Because our criminal system is so large, they have caseloads in the hundreds, sometimes even in the thousands. They may literally have minutes to talk to a client before they have to go into court to resolve their case. Many do not have the time or the resources to investigate cases. And so if a defendant is innocent, the chances are that their own lawyer will not have the time or the resources to figure this out. And so most of the time, defendants have no choice but to plead guilty. And that's what they do, 95% of the time. A few years ago, the American Bar Association conducted an extensive year-long study into the way that the constitutional right to counsel is actually implemented across this country. And at the end, it issued a report entitled Gideon's Broken Promise. And so now you know what that means. In that report, the ABA said that it had come to, and I'm reading from the report now, the disturbing conclusion that thousands of persons are processed through America's courts every year either with no lawyer at all, or with a lawyer who does not have the time, the resources, or in some cases the inclination to provide effective representation. All too often, defendants plead guilty, even if they are innocent, without really understanding their legal rights or what is occurring. Sometimes the proceedings reflect little or no recognition that the accused is mentally ill or does not adequately understand English. The fundamental right to a lawyer that Americans assume apply to everyone accused of criminal conduct effectively does not exist for countless people across the United States. The constitutional right does not exist. In other words, it's not enough to have a constitution. It's not enough to write down grand-sounding rules and principles of fairness at the founding of a country. We have to make those principles real, year after year after year, century after century. If we want a criminal system that establishes justice, then we need to stand up for the rights that make such a thing possible. So what does it mean to stand up for the Constitution? Well, our very own Loyola Law School does this in a number of ways. For example, we were the first ABA-accredited law school in all of California to create a pro bono requirement for graduation. This means that every single Loyola student contributes hours of free legal services to help those who can't afford a lawyer. Our Center for Juvenile Law and Policy is at the cutting edge of establishing justice for children who are caught up in the criminal system. Loyola students represent young clients who have been charged with crimes. Our students file appeals and actually argue before California courts to try to improve the law. The center engages in research and advocacy to push the Los Angeles County juvenile justice system to treat children in a more accurate and fair way. And because the LA County juvenile system is the largest in the country, the work and efforts of our center often become examples for lawyers and advocates around the nation. If our juvenile center is establishing justice at the very front end of the criminal process, then our Innocence Project is doing it at the back end. Students in the Innocence Project represent people who have been convicted, but who didn't get fair trials, and therefore who may be innocent. The students collect new evidence, they make new legal arguments, and they fight to get their clients new hearings so that they can finally get their proper day in court. Just last October, the Innocence Project obtained an acquittal and a pardon for Obie Anthony, a Los Angeles man who spent 20 years in prison for a murder he did not commit. As you can tell, and as you can imagine, we are extremely proud of the work that our students and centers do. So I'd like to end by thinking about why it is that we need law students and volunteers to make the criminal system work the way it's supposed to. Why is it that the American Bar Association tells us that the right to counsel doesn't really exist in this country? Why is it that we have flouted the Sixth Amendment to the Constitution? Well, part of the reason is that criminal defendants are not a very popular bunch, especially in an election year. No politician thinks they are going to ride the tide to electoral victory standing up for people who have been accused of crime. And it's worth remembering that the founders who wrote the Constitution understood this sort of unpopularity very, very well. They knew that unpopular groups, be they people accused of crimes, religious minorities, people with contrary political views, that such groups would always have to struggle to get their own government to treat them properly. And so the Bill of Rights, of which the Sixth Amendment is a part, was created with built-in structural protections for these unpopular Americans, precisely because the founders understood that the political process by itself might well not be enough. So the First Amendment protects our rights to speech, our rights to assembly, our religion, whatever it may be. The Fourth Amendment protects our privacy when the government wants to get information from us. And the Fifth and Sixth Amendments protect us when the government accuses us of a crime. And so I would like to ask you to do something that I always ask my students to do. I would like you to think of someone that you know who has committed a crime. Not that got caught, but somebody that you know, a friend, maybe a family member, who did something that they weren't supposed to do. Maybe they possessed alcohol before they were legally permitted to do that. Or maybe they downloaded a song or a movie to which they did not purchase the copyright. Or maybe they drove a car when their blood alcohol content was over the legal limit. Whatever it is, you think of that person and have their face in your mind's eye. You too, President Burcham. Okay, got them? All right, now, everybody raise your hand if you cannot think of anybody. All right, now look around. Everyone except one person knows a criminal. That's what that means. It means that we all know somebody who needs or might need the protection of a constitutionally guaranteed lawyer, the protections of the Constitution itself, to ensure that they are treated fairly and with dignity. And so no matter how old the Constitution gets, it will always be our job to keep it alive for ourselves, for each other, the people we care about, and for the people who need it most. And with that, I'd like to open up the floor to any comments or questions that you might have. You like my students? I can show you the app.
I'll start with a question.
Okay.
I think for students in the audience, it's very hard for them to imagine themselves just a few short years from now doing what you talked about, having responsibility for 3 minutes a person, protecting someone's youth from crime. It's so different than anything that they've experienced up to this stage in their life. Can you talk to them a little bit about how they make that transition, that journey, from where they are now to perhaps just 2 years from now, being on a thesis project or working in these clinics where they have so much responsibility for someone's life?
Well, that's a great question. So it's a really wonderful and amazing thing to see law students who are not much older than you, many of them, and who are not yet lawyers. These are people who may have just entered law school, have been there 2 or maybe 3 years, taking on the responsibility of defending an innocent person or representing a young person in court. And it's scary because it's important. Everything important should be a little scary. Otherwise, you're probably not appreciating how important it is. And one of the great gifts that I have had in my own life of being a lawyer is that it gives so many opportunities in different periods of your life to stand up for other people. And that is something that I bet that all of you have done. It's not a clean break. It's not a bright line for standing up for someone in your family or standing up for a friend or noticing in an institution that you learn in or work in that someone's being treated unfairly and trying to do something about that. Those are the first few steps to what it feels like to then take the skills that you learned in school, maybe law school, but maybe another form of education, to deploy those skills on behalf of somebody else. It's one of the great satisfying things that the legal profession, but also the medical profession and many other professions offer us that opportunity. And the constitutional right to counsel has been an invitation to thousands of young people over the past 50 years to take the opportunity to use their education and use their learning and use their skills to be deployed on behalf of somebody else. And I'm happy to say, so I graduated from law school in 1995 when loan forgiveness and support for public interest work was much lower than it is today. And now Loyola Law School has help and loan forgiveness for students who choose to become prosecutors, who choose to become public defenders, who choose to go into government. The federal government provides help, loan forgiveness programs for people who go into public interest work, like being prosecutors or public defenders, to make the criminal system work the way it should. So there are many opportunities these days to use the skills of being an attorney to do the kind of work that Gideon and the Sixth Amendment invite us to do. So it's really a very exciting time. Plus, it's really hard to get a job at those fancy law firms, so it's a really great moment. Yes, ma'am.
I have two questions. The first one has to do with I sat in a speaker who was helping the ODM committee in saying she's starting a business project. I mean, that's in my mind, but so maybe you could talk a little bit about the state of California initiative and sort of what that would mean for the criminal justice system.
Yeah, I don't know the details of that, so I'm not really going to be able to speak in an informed way about that right now.
Okay, and then I also wanted to ask you, if you wanted to public interest law, do you advise trying, because clerkships are so difficult to get, so I was wondering what other options are there other than clerkships if you want to do public interest law out of law school?
So does everybody know what a clerkship is? So a clerkship is essentially an apprenticeship with a judge after you graduate. And you're right, they are hard to get. They're wonderful. They are an entryway into legal jobs, but they are not a necessity to get legal jobs that you want. And one of our jobs at the law school as professors is to make sure that each student gets the support and counseling to figure out what's the best way to navigate what is really an immense profession. I mean, there are as many ways of being a lawyer as there are, being a nice person. I've had students who never practiced, right, who never went into a courtroom but acted as legal consultants, who worked in organizations, who wanted to structure public interest-like programs and needed advice. I've had lawyers who've become, students who have become litigators and stood up in court just like in the movies and made objections, and everything in between, working for companies, working for the government, working for state and local entities. So rather than, and I think we're all encouraged to do this, but I do vaguely remember being in school. All too often, we look at the items on the list that we know, and we think they're the only items, right? So we know about clerkships, so we say, either I need one of those, right? But the world is much, much bigger than that, right? And the legal profession in particular is a great place to have some imagination. The reason that the Founding Fathers thought it was so crucial to have the right to counsel built into the Bill of Rights. The Bill of Rights is short. We have the shortest constitution in the world. Everybody else's constitution just runs for pages, right? And we need one of these, and we need one of these. The Founding Fathers zeroed in on what they thought was really crucial to establish justice and form a more perfect union. And they thought lawyers were part of that crucial bundle. There are so many ways to be a lawyer, to work in the private sector, to work in the public sector. So I wouldn't get deterred by the gateways, because there's so many gateways, and at any law school you go to, part of the jobs of your professors is to help you figure out what the gateways are, to figure out, most importantly, where you want to end up. Yes, sir.
I've read that there's been like an excess of lawyers and a lot of unemployed lawyers right now. How come people aren't drawn to like criminal defense, like being that kind of lawyer? Why are there lack of those, yet people are unemployed? What are those barriers?
Yeah, so there's some practical ones and then some sort of zeitgeist ones. So practical ones are that, so even in government, that's, getting those jobs are competitive. Right? So not anybody can be a public defender. They take some training. So for example, Loyola has a number of clinics and experiential programs to help students train to be in the world of criminal law, to be a prosecutor, to be a public defender. But people who want to do that work can do that work, right? I mean, like anything that's hard and worth doing, you have to work to get there. I think that the barriers are connected to something I said a little earlier, which is that in the media and in the public discourse, criminal defendants are not a popular bunch. And we don't often hear about the rewards and the values of standing up for people who don't have representation, who may not have had anyone in their lives stand up for them before, and how satisfying that can be. And so, it's because crime itself has become such a hot button political issue that I don't think that the rewards and benefits and the satisfaction of working as an attorney in the public interest are fully aired. And so sometimes it takes a little sleuthing around to figure out whether that makes sense for you, or whether it's something that you might want to consider. So sometimes public defenders say, so this is a very common question that public defenders get, how can you do that, right? How can you represent a guilty person? And so there are a number of answers to that. So one of the answers that's apropos for today is often public defenders will say, sometimes it's challenging, but I don't only represent defendants. I represent the Constitution. Because it is only by having an attorney that the rights in the Constitution will have any meaning for anybody. And so for many people I know who work in that world, it is a huge source of pride. And if that's important to you, and if thinking that way about what your life looks like is important to you, then it is really worth sleuthing around. Yes, yes, yes.
So recently there's been a big push to value security, national security over justice. So I wanted to know what your opinion is on individuals who would be considered terrorists, who are not afforded trial by the jury of their peers, but rather jury by a criminal, or by a military tribunal, and then they're also not afforded counsel. So what's your opinion on that?
So sometimes we have constitutional moments, right, where, as I said before, most of us are spoiled. We have nice lives. We are not being rounded up based on our views when we walk out of this institution. We can think and do pretty much everything we like. And so we don't always appreciate what it means to have these values written in a constitution, except every once in a while. And then every once in a while we have these moments where we go, those rights are expensive. We have to pay for them. We have to give something up in order to have public trials of people we suspect may be terrorists. It may not be the easiest path to give lawyers to people who we think may have committed crimes against this country. So I don't think that those are easy answers. I think that they're easier to understand if we see them, and Professor Gersman can talk to this better than I can, but if we see them in historical context. The Civil War was like that, right? The country was being rent asunder. There were, and the North wanted to detain Confederate soldiers who were conspiring against the Union. And so President Lincoln did a radical thing. He suspended the writ of habeas corpus. And in effect, and there's a provision for it in the Constitution, he said, for this national emergency, we are going to change the constitutional rule, which means that we can lock you up without a trial, without a lawyer, without telling you why, just like we now see the government sometimes trying to do in the terrorist context. And there's a very famous case called Hamdi versus Rumsfeld that was decided a few years ago. And I recommend to everyone Scalia's dissent. The case decided that under certain circumstances, the government could detain people indefinitely, but they had to have a hearing and they had to get a lawyer. And Scalia wrote in dissent that our Constitution does not provide for that. Our Constitution says that unless you do what President Lincoln did and suspend the writ of habeas corpus, if you want to detain someone, you have to charge them with a crime, and you have to tell them what the crime is, and then you need evidence that they did that crime, and then you need to give them a lawyer and a trial to figure out if they really did it. You have to treat them just like every other criminal that we ever had. You charge them with treason. You can charge them with the very serious crimes in the federal code that encompass terrorist acts. But you can't just put them away in a dark closet. And it's a really eloquent exposition, I think, of this idea that if we want to have a constitution that doesn't need work, then we have to pay when it requires us to do things in an inconvenient way. One and then two.
You were talking about overworked public defenders, and I was wondering, do you think that there are better incentives for public defenders or like lawyers to become public defenders, that the justice system would be more effective, or would be like what would be a way to keep them less, like having less work and maybe be like the most effective like form?
Yeah, so one of the challenges is that we keep arresting and charging more people with crimes, but then we don't allocate more money to the attorneys who have to represent them. And so that's the big structural challenge that we see in so many states, that there's no limit at the front end to how many people can be brought in the criminal system, but there are financial and fiscal constraints on the system's ability to process that, right? And so many public defenders' offices around the country have taken, sort of a creative tack towards this challenge. So there have been public defender offices, for example, in Baltimore, who temporarily went on strike. They said, we're not going to provide an effective representation to our clients who walk in that door. We have too many cases. We can't function as the counsel guaranteed by the Sixth Amendment to the next person who walks in the door. Therefore, we can't represent them. And so, of course, what happens is the entire system grinds to a halt. And then the state of Maryland came up with some more money. There are class action lawsuits around the country challenging the case overloads of public defenders. The American Bar Association has been very engaged in advocacy and trying to promote better regulation of caseloads and public defender funding so that we can really provide meaningful counsel to everybody we choose to put into the criminal justice system. It's a very interesting arena, both for public defenders who are trying to improve the system, but also for legislators and advocates and writers and other folks who are trying to understand how is it that our criminal system works and how do we think that it should work.
Hi, thank you. I just had a question in regards to the statistics about earlier. 30% of people under 23 are arrested at least once. How do you think it reflects on our criminal system? Does that say that we're effective, or does it say otherwise?
So I don't mean to be law professory, but it does, of course, depend on what you mean by effective. So one view is that we use the criminal system to do too much stuff, right? That 22-year-olds are not best handled through arrest and prosecution when they do things that they shouldn't do, right? That there are other ways to talk to you guys, and that the criminal system should be our system of last resort. And all too often, we now use it as the tool of first resort. We don't want you to do something, let's make a law against it and punish you if you do it. And that's why, as I said during the talk, the US criminal system is the largest in the world. We use the criminal system more than any other country uses it to educate, to govern, to nudge people's behavior. But in our real lives, we don't turn to the criminal system first to figure out how we should behave and what's right and wrong and what we should do. I often ask my students at the beginning of our criminal law class, how do you know what you should and shouldn't do? And we make a list. Say, well, my parents, my friends, that could be risky, but my school, my religious organization, movies. Nobody says the police, right? Nobody says the criminal law. That is not, in fact, the first way that we learn how we're supposed to behave and what's right and wrong. So is it effective? In my personal view, I don't think it's an effective way to do what we should be doing, which is figuring out how we should all behave and adhering to those rules. I think there are less punitive and more effective ways of doing that. Yes, ma'am, in the back.
Towards the end of your lecture, you talked a lot about how the Constitution still needs to be living and how we need to stand up for it. But Scalia's dissent that you talked about there is a very big proponent of the idea of original intent as a constitutional method of interpretation. Do you think that the best method and the best outcome from the criminal system relies on the idea of original intent, or do you think we need to relook at the way we look at the Constitution?
That's a nice question. So does everybody know what original intent is? It's a theory of how we should read this crucial document that is the Constitution. Should we read it by reference to what James Madison actually thought it meant? Or should we read it in a more historic or situated way that accounts for modern values, right? And so Scalia is also a proponent, although he's not always consistent in his own readings, no offense, but he's a proponent of the idea that we should look back, right? And so that's not my cup of tea, right? If it were me, I wouldn't do it that way. But here's why I cite his dissent, right? And here's why I think it's worth being open-minded, right? Because we can disagree with a school or a way, but in the end, we're using our discourse about the Constitution to figure out what kind of society we want to have. And there's some things about the Founding Fathers that we really wouldn't want to emulate, right? They had some very bad views on, the role of the vast majority of the population, women and African Americans. So we wouldn't want, we don't go there anymore. We are a different country than that. But they did know some stuff. They knew some stuff about government overreaching. They were really good on liberty and choice. Right? They were really good at some things. And it's worth remembering that we have not jettisoned the Constitution that they wrote. A lot of countries do. Constitutions come and go, but ours is not only the shortest, but also the oldest one that we still pay attention to. So I don't think we should throw out the values of originalism in the sense that we should give credit where credit is due, and particularly in this arena when the founders recognized a fundamental value that we have in many ways abandoned and not lived up to. I think it's worth remembering what they thought. Yes, sir.
I mean, it's just,
the absolutist monarchies. Could you briefly mention, I guess, how, before we actually had a Sixth Amendment, and how that came into being, or concepts that led to that?
Well, so the Sixth Amendment didn't always mean what it means now. So the right to counsel, it used to be under British law that you weren't entitled to have a lawyer with you in court at all. At least if you were charged with a serious crime, which back then was almost everything. Think Dickens, right? People being hauled into these courts. And felons were not entitled, so that if you retained a lawyer, the law was that you had to speak for yourself. In effect, the law said, if you have done something so terrible that we've charged you with a serious crime, you can't hide behind a lawyer. You need to defend yourself. And of course, our criminal system looked very different back then. It was much less formal, and lay people could more meaningfully speak on their own behalf. And so in some ways, the right to counsel also encompassed the idea that if you wanted a lawyer, you could have one with you. And what Gideon did is, as the quote that I read you demonstrated, Gideon said, but what kind of criminal system is it that we have? We don't have that old system anymore. We have an adversarial process with paid professional police and prosecutors. The government hires lawyers to do this work. And so in our adversarial system, any person too poor to hire counsel will not have a fair trial unless they have a lawyer. So it was a recognition, not an originalist view, but a recognition that our adversarial system has so changed that the right to defense counsel holds a new role. I keep looking over here because you're in charge.
No, say thank you very much. Thanks for coming.